Imagine you are having a conversation with a police officer. Do you feel you can simply walk away, or does the situation suggest you are legally obligated to stay? Understanding this difference is crucial for protecting your constitutional rights. You are considered in police custody for questioning when your freedom of movement is restrained to the degree associated with a formal arrest, even if you have not been formally arrested. This legal determination triggers your Fifth Amendment right against self-incrimination, requiring law enforcement to inform you of your Miranda rights before any custodial interrogation. The primary legal standard for determining custody is the objective, reasonable person test. This means a court will ask whether a reasonable person in your situation would have felt free to terminate the interrogation and leave. It is not about what the officer believes or what you personally feel, but what an average, reasonable individual would perceive. This standard ensures that individuals are protected against psychological coercion that might not involve explicit physical restraint. Several factors influence this reasonable person assessment. These include the location of the questioning, such as a police station versus a public park, the duration and intensity of the interrogation, and the number of officers present. Other considerations are whether physical restraints like handcuffs were used, if you were told you were under arrest, or if officers implied you were not free to leave. The crucial element is the overall environment and how it objectively restricts your liberty. It is important to remember that not every encounter with law enforcement constitutes custody. A simple traffic stop, for example, is generally not considered custodial questioning, as it is typically brief and you expect to be released after its conclusion. However, if that stop escalates and you are told you are not free to go or placed in a patrol car, the situation may shift to a custodial one. A brief detainment based on reasonable suspicion also typically falls short of custody, but again, the circumstances can quickly change. Knowing when you are in custody empowers you to assert your right to remain silent and your right to an attorney. If you believe your freedom is significantly restricted, clearly state that you wish to remain silent and request a lawyer. This clarity helps protect your constitutional safeguards, ensuring that any statements you make are truly voluntary and admissible in court.